Good morning, everyone, and welcome to Startups in the Law, presented by JonesKertz, PLLC, and hosted by Capital Factory. It's January 4th, 2022, second business day of the brand new year. I want to welcome everybody. I hope everybody had a great, holiday season, had a great New Year's. I know most of you are probably back at work right now. But as far as getting started with the new year, we are very excited about the things to come. As far as this webinar is concerned, just to give you a little bit of background about what we do and why we do it. We started this webinar back in April or May of 2020. Right after the pandemic. That was the first episode. We've been doing it every month ever since. We feel like we provide a lot of really good information through this, and it really is more about the information here, by the way. This is not a sales pitch. This is not, top 10 best ways to talk to your lawyer or anything like that. This entire webinar is designed to give you the tools and the information you need to start a business and start it the right way the first time without really messing things up, at the very beginning. That said, we have a huge database, bank of these videos. So if we're not addressing any of the issues or topics that you're concerned about or want to hear about today, feel free to drop some questions about those things in the chat room, as Anna had said here, so that I can see them, and I'll try to address them throughout. We're going to go over the list of topics here in a minute. So if you don't see the topic that you're concerned about there, feel free to just ask. I'll see if I can address it here in the hour and a half that we're going to be on. But without further ado, let's go ahead and get started. I've got some brand new stuff as well as some news for y'all today. JonesKertz PLLC, an entity that I started January 1st of 2020, is now Verge Law. As of December 31st, 2021, we changed our name and I merged my business with another business called Verge Law Group, and we dropped the group name and decided to just call ourselves Verge Law. This is something that we've been working on for around 6 months. And to give you a little bit of background, back in the middle of 2021, the State Bar of Texas held a vote, and they said, yes, you lawyers are now allowed to operate under what's called a trade name, or, basically a corporate law firm name, meaning, I, as a lawyer, don't really ever have to refer to myself, as Kertz anymore on the entity name. So, and neither does my business partner, Matt Jones. This is great for us, we think, because, as far as what we do, it's not really about me or Matt Jones. It's more about, the law that we practice. It's more about the people we serve. And we think, these companies being on the verge of greatness, on the verge of something big, and us helping them is really the focus there. And also, I want this business to outlive me, and so as far as keeping my name on there, I really don't have a sense of ego as far as wanting my name to continue to be a part of it long after I'm gone. I don't really feel that's necessary, nor do I feel that that's appropriate. So, but that said, just to give you some details in case you know about us before or have seen our stuff, like I said, our law firm recently underwent a merger. We are now, a Texas professional corporation. It's still the same attorneys and staff members, but now, with a more national focus, we can now operate in 48 separate states under that name. And I'm sure the other 2 states that are holdouts on that rule, under the trade name rule, are probably going to come around here in the next few years. We're still officing out of Dallas and Oklahoma City, though we're opening an office in Austin in June or July of this year. We're still in talks with the person that we're talking to, about salary and compensation, but we'll be hiring them very shortly. Fingers crossed. That said, nothing really changes. We still run the same law firm the same way we used to. But, we're going to be, we hope that as far as expanding, our law firm, that, the name helps us do that in ways that weren't possible before. That said, as far as, my contact information, the only thing that will change is my email. Actually, I probably need to make a correction to that. It should be kkertz@vergelaw.com, not Kyle@vergelaw.com. If you're looking for help in the Oklahoma area, feel free to hit up Matt Jones. He's based in OKC at mjonesvirgil@vergelaw.com. His phone number's there too. That goes to his cell phone. And then, my number right there, 214-736-4462. Feel free to hit me up if you have any questions, as far as some of the stuff we're talking about today, or some of the law that we're going to be talking about today. That said, I want to explain a little bit more about the mission here and why we do this. Not that this is a catchphrase or anything like that, but it's kind of turned into that. I firmly believe that better education, as far as starting the business, as far as growing the business, as far as the contracts you need to do that, and understanding when you need things, leads to a better foundation, a better legal foundation for the business, which leads to more successful startups. And keep in mind, we start these businesses with the end in mind. We start these businesses hoping that, at some point in the future, we're structuring them at the very beginning for, acquisition or merger or growth, or eventually, if necessary, just shutting them down, right? We structure them at the very beginning, with the end game in mind. And we believe, that as far as the information that we provide through this webinar, that usually people are better off than they were before, because a lot of the times, especially at the beginning of the year, people are trying to start new businesses. It'll be the first time they've ever started a business. And, it really is critical that in those first, 30, 60, 90 days, that you gather and collect the information that you need and are going to need for the next year, right? That's not to say that we're sitting here pitching all the legal all up front. We understand that everybody is bootstrapping. We understand that everybody is making sure that they're covering expenses when they can afford to. That said, eventually you're going to need something along the way. You need to be able to figure out, what kind of attorney you need, then how you're going to get that information, how you're going to get those documents, how you're going to get those contracts, be able to direct the people that you are talking to, as far as outside, third parties, as far as law firms and accountants and other specialists. So, that said, just keep in mind that, watching these videos can indeed help your success rate. In general, our clientele, has a very low failure rate. And that's due in part to the fact that we start out with those people at the very beginning, and they call us and we steer them in the right direction before they make a mistake, or before they go down the wrong path, right? That's not to say that, that's not to say that our clients are helpless. Our clients are very smart people. They're just not specialists in, all the ins and outs of contracts, right? All the ins and outs of, startup law. That said, the focus here, we're primarily tech startup lawyers, but I will tell you, if you're starting a different kind of business, just be aware that, a lot of this stuff translates very easily to other, types of businesses. It doesn't exactly just affect tech businesses. That said, here are the topics we're going to cover today. Things to look for in 2022, as well as some legal updates. We're going to go through some stuff that you probably haven't heard of or seen yet. Maintenance items for your business. I should have said 2021 taxes. I apologize for the typo there. Public information reports. We're going to talk about two states, Delaware and Texas, since those are the two majors that we serve. I'm actually going to go over the anatomy of an NFT deal that we recently did, which I think will be eye-opening for those listening. So, if you're interested in that sort of thing, stay tuned, because we have, quite a lot of information about how that went. And it was very eye-opening, not just for us, but, as far as the total industry goes. We've, for us, I understand, NFTs, and we understand how they work, but as far as the anatomy of the deal goes for that sort of thing, the underlying deal is super interesting. And then we're going to talk about executive employment agreements, hiring startup staff the right way. I'm going to go through, offer letters, but I'm also going to go through executive employment agreements and how to bring on people, when you might be a little bit further along, and you need like a CFO or a CIO or a COO or a CTO. You need a specialist, and you need somebody to take on a director role or an officer role in your company. All right, so without further ado, let's go ahead and get started. Like I said, feel free, drop those questions in the chat. I'll be available to answer them throughout. I'll be looking at this, actively. Legal disclaimer before we get started, though. This is not legal advice for you or your business. Please don't act on this info without legal advice from an attorney. Doesn't have to be us. I would recommend that you find one. You can usually search for a startup lawyer in Texas, and you can find several very qualified people in Dallas, Houston, and Austin. Outside of those three cities, though, you're going to have trouble finding somebody who's actually a specialist in startup law, especially tech startup law. Like I said before, or like I always say, there are no absolutes when practicing law. We frame everything based on facts available and conduct research to reach legal conclusions. We never make, just offhand decisions or anything like that. We gather facts, we ask questions, we orient ourselves. And if necessary, if I don't know the law off the top of my head, I make sure we look it up before and make sure we provide the answer to the client, the way we should. And also, I want you all to remember, you're not a lawyer unless you are one. In some cases, even if you are a lawyer, a lot of times that doesn't mean that you would be capable or competent at drafting contracts yourselves or starting, or starting a company up yourself. It is not against the law for anybody to start an LLC or a corporation or a limited partnership or any other type of entity. But I will say drafting contracts, if you're going to do it yourself, just remember the old adage, the person, the person who represents themselves has a fool for a client, right? That's not to say that you can't or never will, execute a document that will protect you the way it should if it were written by a lawyer. That's just to say, we're trained, to look out for certain things, right? Moving on, franchise tax filing dates and info. This is not sexy stuff, so I'm going to go through it really quickly. For businesses operating, gosh, I got to change this stuff. For businesses operating in the year 2021, sorry about that. You have until May 15th of 2022 to file public information, no tax due reports. Taxes due if your business made more than $1.23 million last year. That threshold, by the way, is up, from the previous year. The previous year was $1.18 million. It goes up based on the consumer price index, okay, every other year, basically. And then, the penalty for filing late is $50. That said, if you are going to file late, just remember that $50 isn't going to kill you, but, in the event you don't file, it might jeopardize the active status of your entity. It might jeopardize the ability to operate under your name because, eventually, if you let it go long enough and it lapses for long enough, the Secretary of State or the Controller's office will basically deem your entity, forfeited for franchise tax purposes for failure to pay those franchise taxes or failure to file public information reports. So really the final message is here, don't wait, do it once you've balanced the books for 2021. Once you've figured out your final revenue, once you've figured out your amount of expenses and your profit for the year 2021, go ahead and file that public information report with the state of Texas. If you are operating and doing business in Texas and you're registered to do business in Texas. Delaware franchise tax filings for LLCs, the deadline is June 1st. The minimum that you would have to pay as far as keeping your business active in the state is $300. That usually doesn't change. You usually don't have to do anything weird or tricky with that. For corporations, the deadline is March 1st. The minimum is typically $400, and there are late penalties for that as well. I don't know those off the top of my head because we usually don't let that become an issue. But just keep in mind that, the minimum is typically $400. And also keep in mind that when we start Delaware corporations, they are started purposefully to ensure that we do not pay more than that typical $400. If you are paying more and you had a lawyer start that business, you are probably you have probably formed it wrong. That said, just remember that most corporations are going to be using what's called the assumed par value capital method. As far as as far as calculating franchise taxes. The Delaware Secretary of State has a spreadsheet. It's a calculator that you can use to plug your information in and figure out how much you owe. If you come up with a number that's more than $400, I'd recommend you ask somebody for help on that, because it means you probably did the calculation wrong. Okay. That said, just don't forget about it. We're going to be doing one of those. We're going to be doing one of those this week. We're going to be reaching out to our customers, who form Delaware corporations and have Delaware corporations, and just reminding them that they need to file their franchise taxes. All right, moving on. Recent news, legal updates, and things to look for in 2022. This is going to be pretty short as well. Corporate Transparency Act goes into effect this year. At the beginning of this past year, at the beginning of 2021, we caught wind that a law was about to go into effect called the Corporate Transparency Act of 2021. Effectively, that act is designed to ensure that the federal government receives disclosure of the beneficial ownership interest of all LLCs, corporations, and domestic filing entities. Okay. So basically that means if you are registered to do business in any state, commonwealth, or territory of the US, and that territory is governed, by federal law, then in that regard, you are required to disclose the ownership of the business itself. That said, this is very different than the previous structure. Previously, ownership interest was actually held private information, even from the federal government. That said, for obvious reasons, that's a bit of an issue for the federal government. The federal government has an interest in protecting the public and has an interest in, avoiding money laundering. And this is really tied into, the Anti-Money Laundering Act. The Anti-Money Laundering Act is designed to detect and seek out people who are avoiding, taxes and attempting to clean dirty money through U.S. entities, or clean dirty money through U.S. property and things like that. That said, as far as the overall effect of this, originally we had thought that when this law was going to be passed, that it would effectively mean that there would be a public database of all of this information, that basically anybody who held more than a certain amount of ownership interest in a business was actually going to be included in the disclosures and that would be public information. It is not going to be public information. That is what we found out. Like I say down, toward the bottom here, that doesn't appear to be the case. It's actually held confidential by the entity that regulates this, unless it is in the public's interest to have access to that info, for example, through a FOIA request. So basically, if you do business with that is like military or defense based, or you do business with the federal government on a substantial basis, and it would be in the public's interest to know what that arrangement is, then technically maybe the ownership structure, and who owns that business would actually be, subject to disclosure through a Freedom of Information Act request. That said, for a business like mine, for a business like, a mom and pop shop pizza company down the street, for a business like most of the tech companies in Texas, or, really throughout the nation, there's really no public interest in figuring out who owns what amount of those businesses. As a matter of fact, in some cases, what we see with these things is that, it's not going to be public really at all. That said, this will be more for investigatory purposes for the federal government. So basically, the law is written so that in the event one agency of the government that has this information believes that another agency should have this information, then that agency will be entitled to share it. So for example, if FinCEN decides that it wants to share this information with the IRS or the SEC or another regulatory agency like the CFTC, then at that point, maybe they can share it with them. But that said, let's say that does happen, and then an investigation results in criminal prosecution. They're probably going to look into whether or not that the referral of that information was in fact legal, or in fact they did have a basis or cause to do so. That said, obviously, because this involves anti-money laundering, I believe the IRS is going to be all over this information. They're going to be receiving this information on a regular basis and begin using it to prosecute people for, failure to pay taxes and things like that. That said, I think overall for the general public, this is a good thing. I wouldn't worry too much about whether this affects you. That said, if you are worried about whether or not, your name is going to be disclosed and become public information, I would sort of temper your concerns there, because in reality, most people don't care, as well as, as far as your information being public, really, if you haven't done anything wrong, you should have nothing to worry about, right? If you truly are worried, then I'd recommend that you talk to a lawyer and ask them, what if any impact this will have on you? Because it's, if you do have concerns about this, then I would be more concerned about what you've done. That said, we have had people approach us and say, I want to set up an anonymous, business, which basically means, we can do that either through setting up, an initial trust, which holds the interest of a company, or we can do it by setting up one or more LLCs, and layering those LLCs. That said, even in that situation, you're going to have to disclose beneficial ownership interest, to the federal government. So if I structure a Delaware limited liability company that owns a Texas limited liability company, it's really not going to change very much. As far as the anonymous nature of this stuff goes, those people who are running what we call ghost holding companies are going to still continue to run them. They're just going to have to disclose what they're doing to the federal government and how much they own. And by the way, that goes all the way up the chain. So if I created 10 layered entities, we're really looking at the underlying entity, and then, the money that's passing through all of those other entities, and then the parent holding company at the very top that controls all the others, right? That said, if you have any questions about that, let me know, and we can, talk more about it. 83B elections. Moving on. So technically, there was a huge change that that came about in the year 2020. Somewhere in Q1 or Q2 of 2020. Right after the pandemic had really taken hold, and we understood that it was going to be here for some time, and we understood that there were some health concerns with being in person and signing certain documents while sitting across from other people. The IRS made a pretty practical decision to allow a certain kind of tax election to be made via ESignature. The 83B election is commonly seen, when we start tech startups and issue, what we call vested equity. So basically, equity that's going to be, fully granted to an individual over a period of time. So the common, situation is, what we call the 1 year cliff, 4 years total vesting, where, after the first year of working for a business, you'll receive 25% of your equity, of your allocated equity. And then the remainder of it will vest, on either like a monthly basis or a quarterly basis or some other periodic timetable, in, equal increments, right? In that respect, whenever you grant equity to somebody in that way, or whenever you grant stock options and you're having somebody, pay for those stock options, then at that point, we usually recommend that the person make the 83B election. It's not perfect for all people, but it is necessary, when we can see financially that it makes sense to pay the tax and make the election now. Just so y'all are aware, basically the 83B election allows you to pay the tax on the vested equity now, as opposed to paying it over time. It also prevents a common issue that arises where, if somebody doesn't make the 83B election, then at that point, the equity has to vest. Once the equity vests, then at that point, the company actually has to provide, an appraised valuation on those shares at each interval. So, which is obviously expensive, obviously is something the company doesn't want to do. Whenever we're doing, Series A transactions or large seed rounds, we do have to actually, tell people that, hey, we have to ask them, did you make all the 83B elections? If so, I need to see, the signed 83B election. I also need to see documentation that shows that it was made, within the proper timetable. Basically, I need to see a receipt. I need to see that it was mailed within 30 days of the grant, that sort of thing. Which, by the way, the 30 days, you have 30 days after the election is made, to make it, or after the grant of stock is made, to make the 83B election. This on the back end should save you a little bit of money in taxes because, as we know, if you make that election, you won't have to pay taxes as the company's value goes up, and you're taxed at each interval. In this situation, you're not taxed at each interval, you're just taxed at the very beginning. That said, going back to what I was talking about here, I'm sorry for going on a detour, but I have to explain the basis of the 83B election before I can tell you why this is important here. In general, in the past, the 83B election must have been made, by wet signature. Unfortunately, doing it via ESignature was for some strange reason not allowed, despite the fact that quite literally every other document, a lot of other documents the IRS receives can actually be made via ESignature. For example, you've probably e-signed your tax returns on a regular basis. That's pretty normal. Why you can't do an 83B election, the same way, it was a mystery to me. That said, the temporary rule allowed for e-signatures on these things until December 31st. That has since naturally expired. Going forward, you are not allowed to e-sign these things anymore. They must be hand signed. They must be hand signed, and you must deliver, a manually signed copy to the IRS, within the 30-day period. So just keep in mind that rule is now changed. My hope is that the IRS will actually extend it indefinitely. It's a super practical change, and it actually made our lives so much easier because we didn't have to sit here and tell people, hey, I need you to print that off, sign it in blue ink, and then scan it back to us so that we can mail it on your behalf. All we did was send them an e-signature request, have them sign it, and then we just sent a cover letter with the election to the IRS and made it. That said, if you have any questions about that, let me know. It's pretty straightforward. Just make sure you e-sign 83B elections going forward. That said, anatomy of an NFT deal. We recently did an NFT deal with one of the largest NFT service providers, I should say. This company was based in New Zealand. I can't disclose the name of it, and I can't disclose the name of the artist that we were working with. But I can tell you certain facts about this deal, which I thought are pretty interesting. As far as NFTs, this is not me giving an opinion one way or another on whether this is a great asset to buy. I don't give investment advice in general. I evaluate investments to see if there's protection there, but I don't really say whether I think this asset has meaningful or significant value. This sort of thing, NFTs to me, if you've seen the various versions of them, especially the stuff that you see on OpenSea.io, in general, NFTs to me are like trading cards. They're like Pokemon cards. They're all going to be slightly different. And some of them you're paying a premium to have, the most limited edition. You're paying a premium to have something that really nobody else has. That said, they're all just variations of the same artwork. They're all variations of the same copyright. But that said, some of them come with a little bit different rights. So I'm going to talk about that here in a little bit. I'm also going to talk about some of the nuance to those deals that underlies, the NFTs, that the normal consumer probably will never see and understand, except for through this video. So the basic anatomy, you got two parties. Number one, you've got the artist, or you've got the artwork, I should say. That said, it's possible that you could buy artwork from somebody and buy all the IP rights that come with it, and then go on and create NFTs through that. There are various ways to program this. I've heard of various people programming, the NFT artwork themselves to create the batches of it, which, by the way, whenever these things are created in batches, typically they're making something like 10,000, per batch, right? So, but yeah, party number one is usually the artist, provides the basic framework for all the artwork. So basically they provide, the outline, I would say. They're basic pieces that are similar amongst all artwork. And then, they're basically just tweaking various elements of that artwork. And that's how you get those 10,000 variations. Party number two, the NFT promoter specialist creator. Basically this company either has the algorithm or does, computer programming to generate the artwork. Usually there's some testing that goes on early on with the artwork itself, where they plug the artwork in, get it going, and then, off to the races as far as generating the initial artwork and generating follow-on pieces of artwork. And usually, this entity, you want the person who's, generating the artwork and assisting with that to also assist with, promotion of the NFT prior to and after launch. Part of, launching the NFT and what makes the NFTs have value is promotion within a community, right? If you can get promotion within a certain community, then you can actually, drive up the value of this sort of thing. Similar to the way in which artwork, in a gallery might be driven up. You basically, it's I would consider the building of that community to be very similar to an art gallery hosting a party, right? You're basically hosting. I would consider to be a virtual party, debuting a launch of artwork prior to it, basically getting that floor price up as high as possible. And also usually the floor price, well, not usually, pretty much always the floor price is going to be, basically, a number of Ethereum. If you look at the Bored Ape Yacht Club stuff, you're seeing some of these things go for $150,000, $250,000, $500,000. And for some reason, though, the value of those things keeps going up. I will tell you, I am not really privy, to why they go up. It's not exactly, something that, I would pay additional value for on a secondary market, though. If it's like artwork, then it's like anything else, maybe it does appreciate in value. Like I said, purchased with Ethereum, typically on OpenSea.io. There are other, NFT service providers, but the main one with the most market share is OpenSea. And then, typically both parties are going to enter into a contract to split proceeds from sale under a joint venture or collaboration agreement. The version that we used was called a collaboration agreement. It was very detailed, and it had several other contracts that went into it. One thing that was important to the person that we were talking to was they wanted to maintain ownership of the underlying copyright, which is not as typical with NFTs, but, was important for this person. They had been the original creator of this thing. And if, regardless of whether the NFT launch, and, follow on, NFT launches were going to be successful, they wanted to continue creating the artwork. They didn't want anybody to sit there and, stake a claim in something they created, indefinitely. So basically we structured the terms and conditions of these things as a license of the artwork, which, is slightly different than a lot of those, but at the same time, it still comes with, a bundle of rights. That license, they can do what they want with it, right? They can go put that on t-shirts if they want with it. They can go make money off of it if they want, because they basically own the rights, to, like, they have a license, to do all of that stuff to begin with. That said, the license goes with the artwork. So, they they forfeit the license when they transfer the artwork to somebody else, and sell it. And like I said, these agreements, go into great detail. We talked about sales amounts. We talked about, holdbacks for operating expenses, for this sort of thing. We talked about personnel expenses. We talked about granting, certain other people who are going to help promote the NFT artwork, we talked about giving those people equity in the company that we formed to do the launch. Which, by the way, you pretty much do want to form a company to do a launch when you do this sort of thing, because, you're basically creating an entity that, will earn money and, create additional, that will earn money, hold the intellectual property, and create additional property for sale, right? So, it makes a lot of sense for us to actually form an LLC or a corporation for that purpose. And as far as the other elements of the deal go, the way we structured it was, there will be certain division of profits on the front end, and, that would be between, party number one and party number two there, but also party number three, which was, another collaborator who was also, an actually famous artist that would, go on and create, go on and drum up, some interest in the community here in the U.S. That person would provide contacts and, would provide, names and phone numbers and, provide people who are actually going to buy the stuff, at the very beginning. So basically, further building up the community. We granted that person a little bit of equity. And then, we were going to make sure that they have a share in the initial profits from the first sale. That said, going forward, then we're going to have, a stake in any ongoing profits. That was just going to be divided 50-50 among party number one, party number two. That's different than some of these other deals. And and I've said this before, I'll say this again, and I'll say it again tomorrow. Every deal is different. So, if you're more familiar with NFTs than maybe we are, or think you are, then, you may have seen different deals, or you may have understood it a different way. That's to say, we were serving the interests of a client in that respect. And the client here for us was the artist. We represented that person, in the capacity of making sure that they, did not lose the rights to their artwork, in the process of doing this NFT, which you see some of these NFTs, they're full sale, granting intellectual property rights, all intellectual property rights to, they're granting all intellectual property rights to the purchasers of these things, and it'll go with the artwork, which, is good. If that's what you want to do, if you don't feel like you want to maintain the copyright, to that sort of thing as the original creator of it, then fine. You are allowed to do that. I mean, that's it. Just remember, doesn't mean you can go create offshoots of the same thing. You technically almost be violating copyright law in that way, depending on how similar the artwork is. So, I mean, that would be like, if Bored Ape, hadn't structured theirs the way they did, then technically they wouldn't be able to go on and create additional Bored Ape artwork, right? Which, by the way, if you haven't looked up Bored Ape Yacht Club, I'd recommend you look it up, and you can see how insane some of the pricing on this is. It's incredible. That said, like I said, this is very similar to trading cards. Some people were saying this seems like, sale similar to an IPO. I get that argument, but it's not the same as investing in a business. It's not even close, because you're not investing in the ongoing profits, and you're not, it's not classified as a security because you're not worried about, whether or not this thing increases in value as a result of the efforts of others. And like I said, going back to the community stuff, while that might be an effort to build the community so that, follow-on offerings, continue to have value and the artwork continues to have value, that's not to say that is in itself, you buying shares in the business. These are specifically not shares in the business. It's the same as buying artwork. It's the same as buying a trading card. That said, like a trading card, they're going to be slightly different, but it's, could also be compared to creating limited edition prints of canvas artwork. You're basically creating, potentially a numbered version of that sort of thing. And some of these things do indeed have numbers, right? So, being early on and being one of the first, potentially has greater value than being, the 10,000, right? Um, the best achievement for this for artists, in our opinion, it allows the artist to earn additional money from secondary market sales. So, by way of example, let's say, for example, I create a canvas painting, beautiful painting. It's got tons of value, worth 100 grand, right? I sell that painting for $100,000 to a buyer. While I might maintain the copyright in that painting because I'm the original artist, right? That does not mean that I get to participate in secondary sales unless I have a contract in the US that says, hey, I am going to be entitled to secondary sales of this artwork. You have to disclose all secondary sales to me, disclose the amounts, and pay me within a certain period of time of receiving money post sale. In general, the art world does not work that way. Once you buy a piece of art, you never have contact with the artist again. That person will never know who continues to own it. That said, with NFTs, it's totally different. The artist, gets a transaction fee for the original sale, and then the artist gets a transaction fee for all additional sales. The only country in the world that has really implemented such a system is actually France. A few years ago, France provided for such a thing and said artists ought to be rewarded for the artwork they created, and so they ought to be able to get money from a secondary sale. So in France, the law says they're required to do that. It's very similar to implementing that law, but basically everybody's just abiding by it as a rule of the platform, as a rule of the artwork itself and the NFT structure itself. That said, potentially, I guess you could forego secondary market sales. It is a bit of a tax on the secondary market, I will say, which is potentially, driving the value up or down depending on how you view it. If technically the artist has to be paid, it's possible that the value has to go up in order for the artist to make their transaction fee. It's either that or the artwork is being sold at a discount because it does come with that transaction fee, and it's technically worth less because each time you sell it, you're not going to make as much money as you otherwise would if you owned 100% of it and didn't have to pay anybody. Which, by the way, these people view this as owning 100% of it, but I'm not entirely sure if that's the way you should view it, from a practical standpoint. But I think that solves a major problem for the art market. A lot of, the saying goes that, the only famous artists are dead ones. With the exception of a few people, Andy Warhol was famous during his life, but that was a bit different. Picasso was never really famous during his life. And, other major artists of the time that did very similar art, were not really famous at the time. They might have had a little bit of, rapport. They might have had a little bit of, a little bit of fame, but the reality is their fame, far exceeds what it used to be. But yeah, I think that's a major achievement. I think that's good for the artist, because a lot of these people, they create all this stuff as a passion, out of passion. And in some cases, they all do it for money, and they do commissioned works or things like that, or they do stuff that just, they're inspired by. And they never really make meaningful amounts of money on it. If people can do this via NFTs, to me, that's an improvement. That's real innovation, right? That's just my opinion. I think it's pretty cool. Major differences between NFTs and some issues with NFTs. You need to double check the terms and conditions of sale. These things actually do have different terms and conditions of sale for each of them. I have reviewed a bunch of these. I've reviewed the Bored Ape Yacht Clubs. We've created ones for the ones that we did a deal for, and I can tell you that, these things have a wide range of, different rights and obligations, as far as what you get when you buy one. I would definitely review that. A lot of people are potentially misconstruing, buying an NFT as owning, the artwork and being able to tell everybody in the world that they can't ever take a photo of it or anything like that. Just so you're aware, it's perfectly legal to snap a photo of the Mona Lisa, right? It's that said, is it legal technically? Is it copyright infringement technically to go and use somebody else's NFT? Depends on the terms and conditions of the NFT. Everybody jokes online about it, but is that really truly is it really truly feasible to defend your copyright even if you have the rights to it? When you create these NFTs, if there are so many of them out there, and the internet is just basically able to do what they want with it, after it's been made and after it's been published, right? I don't know. That said, there are other uses for NFTs. For example, there was a car sold via an NFT at a Barrett auto auction, or at a Mecum auto auction, I should say. And there, as far as other things that can be sold, some people are selling, I think, community trips, and so like I saw a rental that was being sold via an NFT, which to me was very similar to like a timeshare. Anybody who owned the NFT could technically rent the place out anytime they wanted, which was an interesting concept, I think. And so basically, as far as ownership of the NFT itself, based on the NFT, it's really whatever the rights are, that come with them. It's the terms and conditions that matter most. So you need to read those. You need to understand them before you buy, because you don't want to spend a ton of money on something, hundreds of thousands of dollars potentially, and then realize, oh, I don't have the right to do anything with this. Some NFTs appreciate. The Bored Ape Yacht Club stuff appreciates. I personally don't really understand the appreciation aspect of it. I get that, the Bored Ape Yacht Club might have been really the first to do it and do it well, and receive the level of promotion and level of, notoriety that, other NFTs have, not been able to generate. For me, I'm having trouble wrapping my head around it. Every time I've asked somebody to explain it to me, it doesn't, they're explaining, that it appreciates. They don't explain how or why. Some people have said it's the scarcity. And I said, that can't be the case because there's 10,000 of them. There are, usually with canvas paintings, even if you have a print of those canvas paintings, you don't have 10,000 of them, typically. A lot of people, they'll have 1,000, or they'll have, 5,000, but they don't typically do, 100,000 of them. So, and I would say, the follow-on launches, decrease the scarcity, they increase the supply. So, the other thing I think most people aren't realizing is this is actually a very efficient way to launder money. I'm not sitting here trying to provide some sort of rubric for how to launder money. That's not all what I'm saying here, but just keep in mind that, like, for people that have converted hard illicit cash into Ethereum and then gone on to, hard illicit cash into Ethereum and then have gone on to purchase these NFTs, sometimes they may be communicating with other people who are buying the NFTs, and they actually might be the same person, or it might be related. And that's where the increase in value is actually happening. That's actually kind of what I suspect with some of this. The purchaser and the seller might actually be the same person, and it's just a very effective way at cleaning money and cashing out. That said, can the federal government here in the US detect that? Potentially, yeah. I don't really know. It's somewhat of a, I would say that, most people, probably are buying this, with genuine intent that this is, a pretty good way to make money, and, a pretty good way to, invest money. But I would tell you that it is a very efficient way to launder money. And I would be concerned that some people are launching specific NFTs just for that purpose. They're, going to do all the steps that I just talked about in the previous slides about building the community and actually creating artwork for it. but then basically, like they're going to sit there and sell off like pretty much every single one of the NFTs and then, completely exit and get out of it, so that they can close the loop on it. So, I mean, that said, when we did this previously, it was really interesting. We're going to do it again, here soon. And so I'm excited about where this stuff goes. I believe, Mark Cuban said a while ago, the billionaire based here in Dallas, Mark Cuban said that, NFTs are different than normal crypto, as far as, you being able to, do practically anything under the sun with them. They're actually very good at, being able to tranche out, ownership in different things. And so, you might be able to buy a car with it. You might be able to buy a house with an NFT. You might be able to, crowdsource rental property and things like that. I mean, it could very well change how we view ownership of certain property. And that said, if anybody has a question about that, feel free to ping me, at my email. Would love to talk to y'all. Moving on, we're going to talk about executive employment agreements, and this will be the last topic for today. The reason I'm going over this is because we recently had a client come to us and ask us, what goes into these things. I'm looking at hiring a CFO, or I'm looking at hiring a COO. And, I really need to make sure that we grant this person the equity that they deserve, but that we're not getting hosed on it. I really need to make sure that this person is going to make it rain for us and is really going to implement the things we need to collect, money from our customers, to make sure that our receivables are the way they need to be. And so there is a proper way and an improper way to hire those types of employees. Sometimes the arrangement for startups is going to be a lot less formal up front, or, the grant of equity is going to be what we call sweat equity, which I want to clarify. If you've talked to anybody and they use the term sweat equity, I want you to be highly concerned about people that use that term. I, as a lawyer, never use that term. Sweat equity is a term used by people who oftentimes screw people out of the equity of a company that they helped start. People that are expecting a significant portion of it, sometimes even as high as 50 or 60%. And then these people say, "Oh no, I'm not going to grant it to you because we never signed a contract." In my world, there's no such thing as sweat equity. You sign contracts for the grant of equity, and you sign them upfront prior to the start of work, prior to the performance of work, to ensure that you have actually done what you need to do, to paper that up. You don't want to create any sort of outstanding or common law claim stating that this person has a right to your equity. Okay. That said, going forward, like, here are some, key docs to focus on whenever you're doing this. Okay. Offer letter, term sheet. If you're in the early stages of this and you think it would be a better idea to sit there and just make sure you understand basic terms when you're talking to somebody before you draft the contract, then do the term sheet. Okay. Or do an offer letter. Sometimes it's easier to get across the finish line with somebody and get them to agree tentatively to something, to do a term sheet. That said, just make sure if you're doing term sheets that you look at whether or not that's going to be binding or not on you. A lot of term sheets are actually non-binding. You also want to make sure that you're not setting yourself up for what's called inducement, for somebody to quit their job prior to you actually providing a contract to them. You want to make sure that, you tell them, "Hey, don't leave your current job. Don't start working for us or doing anything. We're not going to give you an email. We're not going to give you, a phone number for this business. We're not going to give you any sort of rights or duties or responsibilities or pay you anything until we've decided on what we're doing here." In the term sheets, basic terms in those, obviously you're talking about salary, bonuses. You're talking about whether that person gets healthcare and a 401k, whether that person, if they do get healthcare, do they get dental too? Is it going to cover their family? Like that sort of thing. As far as other terms of it goes, though, you're going to be looking at, do we compensate this person with equity, and what is the equity structure? Are we talking percentages? Are we talking amount of shares? How much in terms of vesting? And then what kind of agreement are we going to be drafting? Short, medium, long form, version of, an executive employment agreement. I have two versions of executive employment agreements. They're actually not, we can trim it down to a short version, but, it starts out as a medium form version or a long form version. The reason for that is these things are kind of intense. They're kind of complicated. And we're also covering, terms like termination. Like I said before on one of the other slides, when you start a relationship like this, you need to start with the end in mind. We don't want to create a relationship that can't be terminated, right? You don't want to insulate somebody to the point where, terminating them is almost always going to result in a lawsuit. You need to be able to naturally terminate a contract, and just exit, right? If it's not working out. I mean, that said, other agreements for the granting of equity and options, there will be references to those in these agreements or the term sheets. You'll say, restricted stock purchase agreement or stock option agreement or stock award agreement or something like a, stock appreciation right? Which is different than a normal stock right. Stock appreciation right is really just, appreciation right on stock that's allocated. It's kind of like ghost. It's kind of like shadow. It's kind of like shadow ownership, in that it comes with a lot of the same rights. If they do a dividend, and your stock appreciation right is based on the same shares that are have the same rights as to dividends as others, then you'll receive dividends, right? We're going to talk about the good reason waiver due to COVID-19, which is probably going to be phased out of these contracts, here in the near future. Well, hoping that the Omicron variant doesn't actually become, so contagious to the point where, it really does affect business. The good reason waiver due to COVID-19, which we'll show you an example of at the end, is, one of those things that might need to be included in these contracts. Board resolution. You always want to make sure that if you run a corporation, that has a board, that you're approving, the appointment of this person as an officer. If you don't have a board, then you probably need to either figure out, do I need one? Or, if I'm, the only shareholder at this point, and only officer, do I need to be the only member of the board and approve this? That said, in the event you don't have a board set up at that moment in time, and there's nothing in these agreements that suggest that you need one, or in the statutes that suggest that you need one, recommend that you just have the shareholders agree to the appointment of the officer, because that overrides anything the board will do. Executive employment agreement term sheet. I mean, here are the major terms. Like I said, some of the ones I didn't talk about already: term renewals. In some cases we can structure this. There's like an option A, option B, potentially option C. Option A might be, the term renewal structure, where, I make the initial term, almost probationary. We could make it like 6 months, or we could make it a year. And then, if it's not working after the end of the year, then, I have, 60 or 90 days to terminate, right? Usually you want to do 60 or 90. You don't want to do much else, because you need to provide, that the person is, going to be terminated after a reasonable amount of time. You don't want to do like 180 days, unless, of course, for some reason the person is so locked in to the business that you would need 6 months to transition them out of it. Which, would almost never be the case. Normally, most people's jobs are easy to unwind that way. That said, sometimes you might do the longer, instead of the shorter, because you need that person to stick around long enough for you to make it known that, hey, we're going to be taking over that person's, responsibilities and accounts, so that it causes less damage to the business. People who leave immediately at the executive level, especially for, startups that are venture backed, it could really hurt, the growth of the business, because those people are so vital to making it work, right? They're basically the people who are making it rain on a day-to-day basis. They're the closers, so I would say, as far as y'all doing that, then, as far as term renewals go, that might be an option A. Option B would be, don't do the probationary period, just make it a simple term with certain renewals. basically you make it, first year, 12-month term, and then, you can do automatic renewals for, second and third year, that sort of thing. Sometimes, you tie the renewal language in with, the base salary, equity comp, bonuses, things like that, and you increase base salary over time based on how often that person stays, or based on the renewals themselves. And then as far as potentially option C, you could structure it to where the person will remain employed until terminated. That said, if you're going to do employed until terminated, just make sure that the termination language, severance language, your termination rights, and whether that person will be owed equity or not, are in line with what you want. If your goal is, hey, I only need this person for 3 years, but I'm structuring a 4-year comp structure at the very beginning, then, you might want to make sure that the termination language allows you to cut off the equity comp at that 3rd year and not have to pay that person for all 4 years, as far as equity comp. That said, the termination rights are almost always going to be heavily negotiated, and rightfully so. Anybody who's going to drop their name down as a fiduciary, for a business, like if you're a CFO or a COO or a CEO, they ought to be, in some cases they ought to be insulated, from being fired. They ought to, there ought to be a cure period for certain things that they might have done wrong or, might be accused of doing wrong. That said, as far as termination rights go, I will tell you, we have previously done deals, or well, actually, we've previously assisted with litigation, with other law firms, employment litigation law firms, where, in one instance, we were able to get the former CEO of a major venture-backed startup here in Dallas a $250,000 settlement because the people who terminated this person's employment missed the termination date by 1 day. The notice provision said 15 days. They only provided 14 days. And actually, they sent a letter, which was a smoking gun, where they had specifically referenced, firing the person, without giving them the necessary amount of notice. And originally, when we were in that situation, the former CEO was like, I feel like that's very trivial. Should we be arguing about that or focusing on the other facts here? And I said, no. As a matter of fact, if I win on that claim, I win all of my claims. That's actually the path of least resistance here. And so what we did was whenever that came to be, because that person was a really large shareholder of the company and was one of the original founders, we were able to actually send a books and demands records where we explained all of that. Instead of sending a normal demand letter, we sent a books and records demand under Delaware law, and they caved almost immediately because they knew they were wrong. We explained it to them pretty coherently, and I'm proud to say that was a success for us, and a success for the client. And keep in mind, the compensation that person was owed just in base salary that he would have been owed if he was terminated without proper cause, was $100,000 minimum. Because they had messed up so badly, they actually had to settle for $250,000 and actually paid the guy over 16,000 unpaid vacation days. It was actually a super significant foul up by the corporation there. That said, other things here: non-competes, non-solicitation, non-disparagement, pretty important, right? You want to make sure that the person, who comes in to work for a very specialized company doesn't sit there and just start up a brand new one. Doesn't sit there and go work for, your direct competitor, knowing all of, the internal information that person, came to see and came to know, that might be confidential and proprietary. So as far as structuring non-competes go, you got to keep in mind that non-competes, the maximum you can hold an executive to in the state of Texas, and really, for the most part in other states that allow non-competes, is going to be about 5 years. That said, keep in mind, if you're based in the state of California, or if your company is based in the state of California, or the individual is based in the state of California, you need to actually have a California lawyer review that sort of thing and make sure that the non-compete for the executive is structured properly. If it is not structured properly, and we can tell almost right off the bat if it's not, that then basically you're going to be just holding a clause that makes really no sense. It's basically unenforceable as a matter of law because the statute says it is. That said, non-competes, some jurisdictions are hostile to them, California being one, like I said, but also Oklahoma, surprisingly enough. Oklahoma itself actually makes it so that non-solicitation clauses and non-compete clauses, if not written very, very narrowly, and I'm talking it's got to track the language of the law, or you are absolutely not going to be able to enforce it, which, by the way, the non-compete, unenforceable pretty much in Oklahoma. Non-solicitation, I call them zombie clauses because they're only enforceable in the event they're written a certain way, but they're basically unenforceable unless the person actually goes and violates it, at which point, it becomes enforceable if it was in the contract, which is a weird way of situating that law legally, but, is what it is. The law is worded that way, actually. Like I said, they're basically dead, but still alive in some way. That's why I call them zombie clauses in Oklahoma. Non-disparagement. Non-disparagement's a big one. You obviously don't want the CEO or CFO or COO of, a major venture-backed startup or major, mid-size or, large company disparaging, the previous employer. Some people leave and they leave on bad terms. That said, if they're going to be compensated highly for their work, they ought not to be allowed to talk about, the bad stuff, right? So arbitration, you see a lot of arbitration clauses in these things. These are argued over. People, I've heard from other lawyers, they say, I don't really like arbitration. Why don't we just do mediation instead? Mediation is actually, a different form of dispute resolution. It's very similar to arbitration, but usually costs a lot less. You can actually engage in binding mediation as well. Arbitration has actually fallen a little bit by the wayside. It hasn't, it used to be popular. It no longer is as popular. I've heard people say that arbitrators aren't exactly the smartest people in the room. Also, certain arbitration clauses need to be drafted fairly narrowly. And you can provide for any number of changes to the rules for arbitration in those clauses. We recently negotiated a deal. It was a limited partnership agreement, not an executive employment agreement, but the clause was still relevant. They had wanted the arbitrator to be able to dispense with all of the statutes and all of the case law, and by that, basically disregard it. And I said, absolutely not. The arbitrator has to honor that. Arbitrators are supposed to be like judges. These are supposed to be secret tribunals, basically. But I want the law itself to be, implemented the way it should be implemented. From a breach of contract standpoint, from a case law standpoint. I don't want anybody to be able to sit there and say, oh, we're able to disregard case precedent because, I like this person better than the other person, or just, without giving an explanation. But yeah, aside from that, effective date versus start date, not super important, but you just need to understand that they're not the same thing. The effective date of the agreement is not the same as a start date of, the person's employment. Okay. The person might effectively become, effectively sign an agreement on, day 1, but really they're starting on day 15, as far as their actual employment and when their salary begins and things like that. Clawback of compensation. I can tell you that clawbacks of compensation are, especially cash compensation, are usually going to be, argued against by the potential employee, the potential executive there. The company obviously wants to be able to claw back compensation in the event of termination for cause. Basically this person did something egregious and wrong, so we should be compensated for the damage they caused and for the fact that we have to go and try to hire somebody else in a very short period of time to cover ourselves. I mean, that sort of thing is often tied into moral turpitude provisions, which are basically just, if you do anything that affects your reputation, affects our reputation, or you do anything that's considered anything but like, a class A misdemeanor, or, basically like parking tickets or traffic tickets or something like that. If you get charged with like reckless endangerment of another human being, or, you get charged with, street racing or something like that, they could potentially fire you over that sort of thing. Which, I hate to use those examples, but, I just want to explain, using those examples, that it's not just, hey, this person was in the news for beating, their wife. It's more actually about, hey, I could fire you over, failure to pay, criminal charges over failure to pay taxes. Like, I could fire you over, doing something that might seem relatively mundane, but you were going double the speed limit and got caught. Like, it's one of those things that you need to, understand that, which, by the way, like, do a background check on these people, make sure they haven't committed any crimes, that might violate this on its face. Right. But also, like I said, but moving on to these other things, just a word on severance. Severance in general, you probably want to structure that so that the person, is required by the further assurances clause of the agreement that in the event that the severance terms are actually going to be activated and they're going to be paid a severance. So basically, we terminate them without cause prior to the end of the life of the agreement, and, we don't provide them a reason. We don't have to, but we tell them, hey, you're going to get 3 months normal salary, though your equity is not going to vest anymore. Obviously all of that's going to be forfeit or, repurchased under the repurchase option. Severance is a good way to avoid having to pay unemployment benefits, especially it's a good way to avoid having your unemployment benefits insurance premiums go up, because you had somebody make a valid claim. So that said, sometimes severance agreements are tied into what we call settlement and release. So as far as as far as this goes, just make sure that you can have people waive certain things under the severance agreement in this. That said, if the person was discriminated against for age reasons or anything like that, and can potentially make a valid claim for that sort of thing, you're going to have a hard time having them sign a settlement and release for that unless they have a lawyer review it first. Does anybody have any questions about that stuff? I've sort of gone through, the entire spectrum of terms for that. Obviously, you could provide for different terms for different people. I'm giving examples and different things that anybody, that people can do to get a deal done. But just make sure, whenever you're doing these deals, keep them feasible. Keep, if you're going to have equity vest based on performance metrics, make sure the performance metrics are both attainable and actually measurable. If you make them so vague that we can't really tell whether or not they're, whether or not we're there or not, then there needs to be, some sort of workaround, such as, within a certain period of time. This has just been an example, by the way, but if it is going to be vague, like, the company is going to have enough for its operating expenses as of X date, then maybe make it so that the board has to say, in writing, whether or not that's the case. And, basically I'll, provide notice to the person receiving the equity that they've received it because they've met the threshold, in the board's opinion. And make it so that, it would be breach if the board didn't provide that, and, basically the breach would make it so that, any sort of silence would be considered, you would be considered, having met that term, right? That might be a way to work around really vague terms. But, even then I would recommend, just making it measurable. You can make it measurable by, hey, CFO, assisted with us actually being able to collect X amount of dollars in, X amount of dollars in, venture funding. So, $500,000 or $1 million or something like that. That's very measurable, very attainable depending on the business. So, position and title, make sure the title makes sense. Make sure, everybody will recognize and respect it. Make sure that people understand it. And, cause as far as telling people what their duties are, generally speaking, if we don't outline the duties in writing and list them all out, then, that person is going to have the duties that would generally be expected of that individual. So CEO has CEO duties, COO has COO duties, CFO has CFO duties, things like that. Like I said, define what you can, leave up to the discretion of the parties if you cannot define. That said, if you are going to leave it up to the discretion, once you do start figuring out exactly what that person is doing, it might make sense to sit there and have board resolutions approving certain duties and responsibilities. Okay. For startups, these situations are a lot more dynamic, than at large private or publicly traded companies where duties are narrower and more defined and are going to be way more heavily negotiated over, on the front end. Also, keep in mind who's the person ultimately report to. That often goes into the contract. Obviously, CEO, well, you may have a C-suite. Really, COO and CFO are beneath in the hierarchy, and report to the CEO, right? And so on and so forth. So a director of finance would report to the CFO, who would then report to the CEO, typically. In initial employment terms, 2 to 3 years makes a lot of sense. A lot of people who are going to be coming in as CFO don't really want to sit there and, do it for much less than 18 months. You can't really make much of an impact, I would say, unless the person is just an absolute superstar. You can't really make much of an impact in less time, nor can you see the value of your investment in less time than 18 months. 3 years is a good place to start. Most venture-backed startups are going to want people to be with the company at least 3 years, if not longer. That said, just keep in mind that this person is, executives are being granted a higher level of authority, higher level of knowledge, higher level of confidential information than, your lower level employees, who we might expect to work for 6 to 9 months. And then, they're gone. They're going to jump ship to another, startup, and that's going to be fine. Like I said, automatic versus noticed renewal term. Sometimes the notice terms can be automatic. Sometimes they can be noticed, meaning you've got to provide written notice of the automatic renewal, or else it's going to be considered automatically renewed or automatically terminated. It can be done either way. It can be done really any way you want, but it's best to make sure that you understand how exactly that's supposed to happen, and that you actually set deadlines for providing that notice if you do have notice terms in there. Sometimes no term renewal language in the agreement. Like I said before, you could take it out, you can modify it. There are a lot of different ways. My personal preference, I like automatic for additional 1 to 2 year terms. 1 year is kind of my comfort zone. You do initial 12 months. Then do, automatic renewal for 12 months, automatic renewal for 12 months, unless the person, unless we terminate, 90 to 120 days or 60 days before. And then, salary, equity, compensation, people go, what do I pay this person? Well, that depends on what your needs are. That also depends on how much money that person could command in the market. You sort of balance salary with equity comp. So, more equity, less salary. Obviously we do want to take into account the motivation of the person. So, I'm currently hiring an employee where, I do want to give them equity, because they're going to help us start a new office. But, at the same time, I want to make sure that, that employee, knows that I understand that, hey, I don't want your salary comp to be too low for very long. Even though we're giving you, equity, I understand that individuals are oftentimes motivated by money and increases in the money they make. They obviously want to see that they're making more and want to make sure that they're able to, see the light at the end of the tunnel there. You also don't want the person who's working for you to be priced out of their friend group or anything like that. Their friends are very much the people that help them, with their success. And, you don't want them to stop hanging out with their friends because they simply can't afford to go to dinner with them anymore, or can't afford to go buy drinks. So, there's living adjustment costs too. So if the person is living in Dallas, you can pay them less than if they're living in Austin. But that's not to say that they're worth less if they go live in Austin. A lot of times you need to be aware that these people could very well just leave, go work for somebody else in the next 6 months, right? So you need to make sure you price that. You price the salary, the way that will make them stay long enough for you to see the value out of them. Like I said, different types of equity. You can see that here. Sometimes we make these things time-based. Sometimes we make these things performance-based. I think a lot of times these people are okay with performance-based, but would prefer, as far as the executives go, they would prefer they just be time-based. And sometimes you pay them, an initial equity, bonus to join, and then, you pay them, over time for staying, right? That said, being able to claw that back, being able to buy that back. Sometimes you want the right to buy back stock in the event they leave within a certain period of time. Like I said, these things change. People, we could sit here and try to create a standard structure for this, but, human beings oftentimes want different things and have different goals for themselves. And so I hate to pigeonhole people, or, put a square peg in a round hole, so to speak, and force them into an agreement that they would really prefer never to agree to. Like I said, health, dental, 401k, other, health and dental, possibly 401k. A lot of times venture-backed startups don't have them. So, you might just increase the, salary comp, to reflect that. Aside from that, cash bonuses. Sometimes you make these discretionary, sometimes you bake them into the agreement. Really depends on what you negotiate. I say later stage, potentially bake them into the agreement. You could do that as an early stage company, but just keep in mind, gotta have the money, can't breach that agreement. Breaching an agreement to pay somebody a bonus is a breach of an employment agreement. It's a breach of, you're basically violating employment law. You don't want them to be able to file, a workforce commission complaint against you for failure to pay. Equity bonuses, sometimes, you're basing them on, some are time-based, like I said, some are performance-based. Consider whether, it will make the person stay or excited to continue making progress for your company. And then I talked about signing bonuses, double-edged sword, just make sure that, if you're going to grant somebody a signing bonus, that it's structured properly, that, if that person doesn't work out and you see that they don't work out, usually in the first 90 days, you can tell whether somebody's a good fit or not. It might make sense to have the agreement specify that, hey, that's, we'd claw that back if, you end up leaving within the first 6 months, or we end up firing you within the first 6 months or something like that. But that said, can we put a term like that into the agreement is another question. That's a very hostile term to somebody you are trying to build a business relationship with and trying to, make a ton of money with. These people are obviously interested in not just, making a ton of money, but, growing the state of your business. Coming in with a really hostile offer, is sometimes not a great look. Restrictive covenants, like I said, non-compete, non-solicitation, and non-disparagement, all very common. If somebody told me that they did not want a non-compete in an executive employment agreement, I would tell them respectfully, we're going to have it. You're going to have to get okay with that. We can, negotiate that term, but it's going to be in there. It's going to protect the company. I can't sit here and not protect the company. We have to make representations, when we sell companies, and we have to make representations when we sell stakes in companies in seed rounds and Series A's, that we did what we could and actually did have every officer, every, founder agree to, these types of restrictive covenants so that they wouldn't take the entire, employee pool with them. They wouldn't take, they wouldn't compete with us for a certain period of time. As far as non-solicitations go, non-solicitations are more about employees, contractors, and, basically current customers. Some states have rules about former customers. For example, Texas generally views solicitation of former customers as okay, because those people, you're not harming, the previous company you worked for. If you're going to go do something and work with a former customer, so long as you're not violating some other restrictive covenant like a non-compete clause. The reason for that is they're not working with that other company, so that other company shouldn't be entitled to, be able to block you from working with them ever. So that's like I would say, we usually draft the non-competes with industry, and similar businesses in mind. Sometimes we specifically name the businesses that we believe are major competitors and say, you're not going to go work for them, and you're not going to work for anybody like them. That said, it's, basically calling out specific businesses is, in a way, I don't normally like doing that unless I can clearly identify the competitors that would damage the company. It's, for me, that's more of like a large business type of thing. That's more like the CEO of AT&T is not allowed to go work for Verizon or T-Mobile. Like that makes a 100% sense, I would say, because, that's ridiculous competitive advantage if those people were to actually work with that person. But, it's, for startup companies, we generally make it more broad. And keep in mind, I'm not usually in the business of forcing people into unemployment for extended periods of time. If a person comes to us and says, this would potentially violate the non-compete, but I'd ask that y'all waive it, or I'll pay to have it waived, then, we'll hear them out. We've actually done waivers of non-competes in the past. And I generally tell people, hey, unless you see super amounts of damage, really high amounts of damage to your company because this person works with this other company, then, maybe allow it, or just take the money and sign the contract to allow it. Termination rights, you can look at this, but as far as what you need to know here, with cause versus without cause, usually, the without cause thing is going to be more favorable, to the company to be able to fire the person at will. A lot of times the person, you're hiring doesn't want to be fired at will. They just want to be fired under normal terms. And then, they want to be fired for cause, basically. They want some insulation. That said, we oftentimes try to negotiate for, potentially a mix of both of these, where, we fire you without cause, then, we're probably going to have to pay you the remainder of your equity, or, we fire you with cause and we're going to have to, we fire you with cause and you lose your equity, or you lose the remainder of your equity, and we get to repurchase the, whatever has vested over time. That said, with cause, a lot of times when you're trying to fire somebody with cause and you provide them with notice, you're walking into a lawsuit, you're walking into, a settlement. You might just keep in mind that if you're going to exercise that term, just know that it could be very contentious, going forward for the next 6 to 12 months, possibly longer if the person decides to actually sue the company for wrongful termination. That said, aside from that, I've already talked pretty much at length about all these things. The good reason waiver is here. Basically, the good reason waiver says, you're waiving your rights, to, certain things such as, protection against salary reduction. That said, sometimes you'll draft this to say, I'm not going to reduce your salary by a certain amount, so like I can reduce it, but I can't reduce it more than 25%, or I can't reduce it more than 20%. This protects the company in a way, in case, there's a super, terrible pandemic that occurs again. I can't imagine that would actually happen, but maybe, you never know. But as far as including these are gonna start becoming less common, though. I would say if I was drafting these, I'd still work it in, because we're still in, Omicron is surging, and if there's some variant that comes along that is indeed killing people on the level it did back in 2020, then we definitely might need this again, because we might need to, if the economy goes down the tubes, we're going to need to reduce salaries for the time being, or at least have the ability to. That said, in the event you don't have this right in the agreement, my recommendation is, ask people if they'd be willing to make a sacrifice to the company, and maybe, grant them additional shares to, in exchange for their reduction in salary. That said, I'm at the very end of my slides for today. Thank you so much for joining us today. If you have any questions, feel free to email me at kkertz@vergelaw.com. We will see you on the first Tuesday of next month. Take care and have a great one. Bye.